Hi guys, in this video we're going to look at whether the best application for you is an EU settlement scheme family permit or an EEA family permit. What is the difference and what's the best route for you? Now I've got some excerpts here which I just want to go through with you. I'm just doing this live, so you have to bear with me please. So let's have a look at the main application form first of all, and this is the page that you'll reach if you're looking at going down either of these routes. Now, an EU settlement scheme family permit is essentially for direct family members, so your husband or wife, civil partner, your dependent children, and it's for situations where you've applied for and secured pre-settled or settled status. So I've got separate videos on this about how to apply both for settled status and pre-settled status, where I walk you through the application which you can actually do on your phone. But where it gets interesting is under the EU legislation. EU or EEA, European Economic Area nationals who are living in the UK have more rights and still have more rights than people who just have British nationality. And I mean that in respect of family members and extended family members and the ability to bring family to the UK. And that's because broadly the effect of EU legislation is to ensure that EU workers are not inhibited in coming to the UK in any way, and they would be inhibited if they were unable to bring their non-European family members from the European country, let's say France, to the UK. If they were allowed to live with their non-European family member in France, but they were not allowed to do so in the UK, then that would inhibit that person as in the capacity of a worker or exercising other treaty rights to come to the UK. And so what this means is that it's easier for a European citizen who's not British to come to the UK and bring in their non-European family member or partner or unmarried partner, which I want to come to in a minute. It's easier to do that than it is for a British person to do the same thing, because the British person, while they're in the UK and working in the UK, are not exercising treaty rights. In other words, they're not exercising free movement rights. So that's important. Now, the mechanism before Brexit for bringing in non-European family members was an EEA family permit, which you can still apply for now, and I'm going to look at that. But the difference now is that there's a special category within UK law, or as a procedural mechanism under the EU settlement scheme, where specifically if you are a European national who's secured settled status or pre-settled status, you can apply and make an application for a permit for your family member, as long as they're a direct family member. Now, the confusing thing about the language of this, let's just go back to it, is that this refers to close family members rather than using the language of the regulations, the 2016 regulations, which is of direct and extended. But at any rate, I would say, before we get on to EEA family permits, that for EU settlement scheme family permits, where you have a non-European, if you have a non-European direct family member, then the easiest pathway is for you to if you're looking to regularize your status, which I would recommend you do at this stage, the easiest pathway for you to do so is to apply for pre-settled status or settled status for yourself. And again, I've got a number of videos on this YouTube channel about how to do that, and with examples, walkthroughs. So you should apply for pre-settled or settled status for yourself, and then once you have the reference number, then you make an EU settlement scheme family permit application for your direct family members. So that's the most straightforward pathway. Now, the issue comes in with extended family. So in theory, your uncles, cousins, etc. And perhaps much more importantly, and this is the example I want to focus on, unmarried partners. So for unmarried partners, so non-European unmarried partners of you, if you're European and you're living in the UK, you have a window of opportunity to bring them in through an EEA family permit, while the Brexit transitional periods are still transitional provisions are still in effect. Now, this is what's referred to here. So, and this is the .gov guidance. It says EU settlement scheme family permit. Apply for the EU settlement scheme family permit. Sorry, EEA family permit. Let me just highlight this. I'm using this new tool for these live streams to try and make it easier for you. There we are, it's highlighted now. Just move this up slightly. So apply for the EEA family permit if you're a close or extended family member of an EEA or Swiss national. So you can apply for an EEA family permit without doing the pre-settled or settled status application. But I would just say there's no point, because a pre-settled status application or settled status application can be processed within sometimes 48 hours. You can have that done, sometimes 24 hours. You can have your decision. So if it's for a direct family member, it's much better for you to go through the EU settlement scheme family permit regime. But if you have an unmarried partner, so someone who doesn't fall within the definition of close family member, then that's when you go for an EEA family permit. And it would still be better in that scenario, in my view, to first apply for pre-settled or settled status, i.e. if you're in the UK. And once you've done that, then you'd be applying for an EEA family permit for your unmarried partner. Now here it references the arguably strange effect of EU legislation, which is that you can be a close or extended family member. An extended family member includes a brother, a sister, aunt, cousin, nephew, or niece. And it's one of the very surprising aspects of, or surprising effects of European legislation, that a European citizen, non-British European citizen, can come to the UK, and as long as their extended family members are dependent on them, and that dependence could include financial dependence, then they can bring extended family members to the UK, including brothers, sisters, cousins. In theory, that encompasses second cousins, nephews, and nieces. You can bring a huge, broad range of family members with you, which would be impossible under most immigration regimes in similar jurisdictions. Now, I'm just going to go to the legislative definition now of unmarried partner, which is the one that I want to focus on. And that's in the 2016 regulations. That's just here. I'm just going to highlight the relevant provision. So someone is an extended family member if they meet a number of conditions, and this is the condition in question. The condition in this paragraph is that the person is the partner other than the civil partner of, and in a durable relationship with, an EEA national or the child under the age of 18 of that partner, and is it able to prove this to the decision maker. Now, I'm not going to deal with children in this particular video, but the test here is whether the person is the partner of and in a durable relationship with an EEA national. So let me close that and let me show you what evidence is required. Now, I've actually gone through a sample application for the purposes of you for this live stream to show you exactly what evidence is required, but I'll show you what the guidance says first. This is the guidance here. Okay, this is the guidance on dependency. Bear with me a moment. Okay, here we are. So, evidence required for durable partners. Let's just highlight that and then zoom in. So, a durable relationship is an unmarried partnership which is normally continued for 2 years or more. So it's not necessary that it's for 2 years, but normally it's for 2 years or more. The evidence the applicant can provide may include proof that any previous relationship is permanently broken down, evidence of cohabitation for 2 years, for example, bank statements or utility bills in joint names at the same address, rent agreements, in other words, joint rent agreements, mortgage payments, official correspondence which links them at the same address, and evidence of joint finances, joint business ventures, and joint commitments, for example, tax returns, business contracts, investment. And then we have evidence of joint responsibility for children, such as a birth certificate or custody agreement showing that they're cohabiting and sharing responsibility for children, and photographs of the couple. This is where it gets a bit intrusive because you need to get into not necessarily sharing love letters, but as near as evidencing the genuineness of your relationship in the absence of a marriage. And then other evidence demonstrating their commitment and relationship. And it says you must always consider the individual circumstances of the application. For example, there may be instances where the couple have not been in a relationship for 2 years or more, but you are still satisfied, you being the Home Office, still satisfied the relationship is subsisting and durable. This may be, for example, where the couple have a child together and a birth certificate showing shared parentage has been provided with evidence of living together. So this is the evidence intended to be in compliance with European law. Now, I've actually just completed an application for you for this presentation, and I'm going to show you what the application actually asks for at the end of the presentation. So I've completed this. This is just a dummy application which hasn't been completed, and before the declaration is submitted, using my own name as if I were a US citizen, and this is the say information that's generated. So the mandatory documents that I would have to show as if I were a US citizen, hypothetically, applying to join as an unmarried partner, applying to join a European who was working in the UK, are my passport, and then proof of my relationship with the individual. I just put in sample here, sample. For example, birth, adoption, marriage, or civil partnership certificate. So in this case, it's not a marriage. I'm unmarried, and I've completed this on the basis, entered the information on the basis it's unmarried. And then it says I would need to provide proof of my partner's identity and nationality, such as a copy of the biodata of their page of their passport or national identity card. And then evidence that she, my sponsor, is living in the UK as a qualified person as listed in the 2016 regulations. Now, what that means is that I can only exercise a right on the basis of a European national's right if that European national is exercising their treaty rights. In other words, they're in the UK as a worker, or as they're financially independent, or they're a student, for example. So they've got to be exercising those treaty rights. And again, this doesn't depend on them having applied for pre-settled or settled status. So they would then need to provide proof that they have been working, for example, in the case of work, pay slips and an employment contract and so forth. As I say, it would be much easier if they had just applied for settled or pre-settled status and they'd got the reference number and you could produce the decision letter then. And then if, Tom Bradford, if I am a member of my partner's household, provide evidence that I am living with them in their house. For example, this could be social services letters, documents from an official organisation, mortgage or tenancy agreements, bank statements or utility bills addressed to me at this address. And then evidence of your relationship. For example, evidence of living together, normally covering 2 years, such as utility bills or tenancy/mortgage statements, or other evidence showing that you have a durable relationship. So it's essentially, akin to marriage. If we focus on this, after you submit your application, you must provide your documents to our commercial partner. So this just goes to procedural matters, and that's straightforward. But you can see that basically it's a fairly easy now, for a limited period only. It's easy now for you as a European national to regularize the status even of your unmarried non-European partner for the time being. And so I would urge you, if you are considering these applications, to make them sooner rather than later, definitely during the course of 2020. And in terms of, just to sort of answer the question, which is best for you, which application route is best for you, and let's just bring them up again. I haven't actually dealt with the evidence for relatives and financial dependency. I might leave that for a separate video because this video is already of some length, but I might do that next time. But to answer the central question, which should you go for? The EEA family permit or the EU settlement scheme family permit? Well, without a doubt, you should, in either case, as a European national, first apply for pre-settled status or settled status. That's number one. And then number two, you've got to decide, do you have is the person in question your significant other? Are they your spouse or civil partner? In other words, a direct family member or, quote, close family member. Then you should go for the EU settlement scheme family permit. And if they are if they are an unmarried partner or as I say, an extended family member of some other kind within the meaning of the legislation, then again, after having secured pre-settled or settled status, then you should apply. And the threshold is so low in comparison with what you'd have to do if you were applying under the immigration rules as a British national, that you should prepare a strong application as you can and apply now. Of course, if you marry your partner, then the sort of evidence we're talking about here isn't required, and the process would be much more straightforward. But if you're not in a position where you're going to do that, then now is the time to apply. So I hope this was helpful. I'm actually doing a course on this subject and some other related subjects, particularly the work visa course, which is going to be published in the next week or so. And I also have completed my startup visa course. The work visa course for the UK is really interesting, slightly different subject, because it's aimed at non-European nationals who are coming to the UK to secure a work visa. But the great thing about that is you'll be able to access sponsored roles and qualifying roles, and then be able to apply through the course program. And on the startup visa course, that's informed by the experience of successful applicants who have been through and successfully applied. And the other courses that I'm releasing are going to be each have like a big value add like that, either informed by the experience of actual successful applicants, or providing a unique resource which you can use to help you come to the UK. After that, I'm also going to be covering work visa courses for Ireland, Canada, and the US. So it's going to be extended from there, but we're starting with the UK. So keep an eye out for that, and of course you can always subscribe and click the notification bell to make sure you're notified when I have new videos. Thanks. Take care of yourself. Bye for now.